I welcome the chance to follow that member, because she issued a challenge during her speech that the opposition needed to do their homework on this bill. And I'd like to ask that member what actually her homework demonstrated to her, because the sense that I got was that actually Sandra Gowdy is under the impression that the Labour government got rid of the idea of recognising excellence within the legal fraternity, and that is absolutely untrue. She said that this bill was about recognising excellence and not dumbing down. She refused, or just chose not, to demonstrate how having senior counsel, which we retained, did not recognise excellence, and how having senior counsel was in fact what she called dumbing down. And if anything, I think what the government is doing is dumbing down our system, because they claim that people don't understand what senior counsel is. People don't recognise what senior counsel is, and so we need to revert back to the old style of Queen Counsel, because that's what people understand. Now, if that's not dumbing down, I don't know what is. And if that member is unable as well to demonstrate to me how our system currently works does not recognise excellence, and I'm sorry, I don't believe that member has done her homework. Labor changed the appointment process. Labor changed the eligibility. We did not change the fact that certain members of the profession were duly recognised. And that is something, of course, that we would retain. But therefore, we can only distill down that actually this bill is simply about reverting back to an antiquated system, which I don't recognise as being my country. I do not recognise this idea that excellence can only be formally attributed if we attach some reference to the monarchy. I think it's an absolutely antiquated idea, and one which makes me, quite frankly, feel quite embarrassed. But let's go through the history of some of this, perhaps so to demonstrate that some homework has been done. This bill reverses the changes that Labour made to the Queen's Counsel regime in 2006, and that was after a lengthy process of consultation and deliberation. It wasn't done on a whim, and we chose to modernise what was otherwise quite an ancient position of Queen's Counsel, but it was, as I've said, by changing the name, eligibility and criterion appointment process, not the notion itself. I do want to refer to one interjection that was made during the contribution by one of our members, by the Honourable Judith Collins, whose main argument seemed to be that we should revert back to Queen's Counsel because Parliament's history lay elsewhere as well, and that we should recognise Parliament's history. Well, it is one thing to acknowledge one's history, and it's another to simply live in it. We have to recognise that as a country we are dynamic, we are moving forward, in the same way that we acknowledge that the Treaty of Waitangi is a living document and a dynamic document, and we continue to incorporate it as we move forward, but not to sit entrenched in history without acknowledging the changes that our country is undergoing. So personally, as I've said, I find it embarrassing that not only would we have gone through this process, which was quite a lengthy one, and then now have simply slid backwards without, I think, a rational justification from the government as to what it is that is not working about this system. I have not heard one argument from the government as to why this system is not currently working, except for this notion of an antiquated title attached to the monarch. I would like to, perhaps maybe if the government's not going to canvass some of the ideas around why we might be having this change, perhaps I'll just canvass them and then argue against them myself. Just a one-on-one debate, given the government seems unwilling to engage. And internationally, I don't think that there's any precedent that we could possibly be following, because Canada has already abolished the title, and so have most of the Commonwealth nations. And I think they'll probably find it quite laughable, not only that has New Zealand abolished it, but then we're jumping backwards soon after. In fact, all Australian states bar one have moved to the title of senior counsel. I find it interesting that, to be fair, both sides of this House have continued to look for areas of commonality, of harmonisation in our legal system with Australia, and that makes sense given the close nature of our countries. In fact, the Trans-Tasman Proceedings Bill, several bills that I've been involved in have all looked at Trans-Tasman harmonisation. But then we go and do this, and I question whether this is the one desperate attempt from the government to demonstrate that we're catching up to Australia, is that by leap-bounding through history over top of them. But, perhaps the government might like to demonstrate that I'm wrong in that regard. But perhaps, in desperation, I thought perhaps I'd look at the regulatory impact statement to see whether or not that demonstrated any solid reasoning behind this piece of legislation. But was again left wanting, because according to the regulatory impact statement, the title of senior counsel, quote, overlooks the historical link between Queen's Counsel and the Crown. So apparently we're doing this simply because we need a history lesson in law, which again I just do not believe is an adequate justification for what the government has done. Historically, of course, the link between Queen's Counsel and the Crown refers to the title's ancient English origins, but where it indicated barristers who were selected to assist the Attorney General in carrying out the Crown's legal business. So the modern QC doesn't actually have the same kind of notion that it once had when first created, given that modern QCs, when we had them, acted for a wide variety of clients, including private individuals and businesses. So you could even argue that historical link that the government's looking to entrench in a practical sense no longer exists anyway. So again, we're still left wanting. In fact, Paul Quinn himself made a contradiction when he said that we needed to have this title to demonstrate the role of Queen's Counsel, but then demonstrated that in fact Queen's Counsel do much more than advise the Crown. So I am not left any the wiser as to why we're regressing, having looked at some of the explanation from the government. So I want to just go over some of the other changes we've seen around particularly eligibility in the appointment process. I think David Parker actually canvassed well some of the issues around the government's decision to change the eligibility criteria. And on the face of it, it does look like it's perhaps a form of elitism, actually. But I actually think it's much more bizarre than that even still. The government believes the extension of eligibility to litigators and law firms failed to provide due recognition to the importance attributed to the independence of the office. Now, I think it was well said by Jack Hodder in his submission on the nature of Queen's Counsel that actually that assumes by default that we can't have any trust or faith in those operating in our legal fraternity. It does create a two-tier perception of independence for some but not of others in the way that they operate, and that's something that he strongly rejected. He actually rejected the idea of any form of elitism within the legal fraternity, as far as I can tell, whether it be Queen's Counsel or Senior Counsel. But I think a lot of his arguments do still hold with when it comes to Queen's Counsel in particular. And it's our view that restricting the title to barrister's sole grants a commercial advantage to a limited number of competitors in the legal services market. And I think, the fact that for nearly 90 years only a fraction of New Zealand's advocates have been eligible to apply for the rank is a ridiculous situation for a country as small as New Zealand. But again, I have to acknowledge the government hasn't taken into account New Zealand's uniqueness in any sense in this bill whatsoever. Also, the appointment process. The government has claimed that the current requirement for the appointment of a selection panel is unnecessarily rigid. So on the one hand, Labor introduced too much openness, and on the other hand, we included an appointment process that was too rigid. I think perhaps we, in the end, had the balance right, and it's the government that's demonstrated some confusion. I think it's unfortunate, given that Britain even has a very open and transparent appointment process, that the government has said ours is too rigid and then really hasn't given much prescription over the way that appointment process would work, and in fact have left it to order in council, and I think that's inadequate. given the calls from the legal fraternity to really make that process much more open. So, as my colleagues have said, this is a backward step. I think it demonstrates